Okay, another area that we frequently get involved in is maintenance of the common area. Here, the rule is very easy to state. The association is responsible for the exterior. The owner is responsible for the interior. By the exterior, I mean the common area. The association is responsible for maintaining the common area. The owner is responsible for the interior space. Now, if you have a condominium, all you have is the interior airspace. That's your responsibility. So, but disputes frequently arise between owners and associations over the common area and the maintenance of the common area. And one case that addressed this issue in a very interesting fashion was decided by the California Court of Appeal in 2008, was Ritter and Ritter versus the Churchill Condominium Association. In this case, this was a high-rise condominium building. The unit owner below complained to the unit owner above that the unit owner above was smoking cigarettes, and the cigarette smoke was coming down into their unit, and they were smelling cigarette smoke all the time. So the below unit owner complained to the unit above, and the unit above said, too bad. And then the below unit owner complained to the association, and the association said, too bad. So the unit owner below filed a lawsuit against the association and the board of directors for not enforcing the CC&Rs and not maintaining the common area. And the argument was that the area below the floor of the above unit and above the ceiling of this unit owner is common area. So the association was responsible for that common area. And further investigation revealed that the reason the smell of smoke was passing from one unit to the other is that the material between the floor and the ceiling didn't have certain fire retardant membrane or substance that, in addition to keeping the smoke out, would also retard a fire that would start in the upstairs unit and spread to the downstairs unit. So there were two problems that developed: not only the smell of smoke, but also the safety feature of the failure of the original developer to install fireproofing membrane in this area. Now, the time period to sue the developer had expired, so the developer was not involved in this case. So the case went up, the Court of Appeal. It turned out the fix on this, fixing this particular problem would cost about $2,000 per unit. So what happened is it went up to the Court of Appeal. The Court of Appeal agreed with the property owner and said, this is common area. The association is responsible to maintain it. They didn't maintain it properly, and it was the association's responsibility. So the association was required to install what was needed to be installed in that common area so that you'd have the proper fire retardant material, and also the smell of smoke wouldn't pass through there. But in addition, the plaintiff's attorney representing the property owner recovered a attorney's fee award of $500,000. An interesting issue on the attorney's fees, and I'm going to talk about this a little later, is as I said, the attorney for the plaintiff sued both the association and the individual board members. He lost the case against the board members, but won the case against the association. So the issue was whether the attorney was the prevailing party in that case, because he won part of the case and lost part of the case. And the court ruled that he was the prevailing party, even though he did lose part of the case.